Hi everybody again, welcome back. We're back at Clarett 1, and we're at the end of Clarett 1. Judge Sheindlin issues an injunction holding the NFL responsible for allowing Clarett into their draft. She rejects the league's labor exemption and non-statutory labor exemption arguments. And it's interesting to see Clarett leaves the courtroom that day as a huge victor. He's to be allowed in the draft, and there's going to be a class created to allow any other similarly situated players to enter the draft within the next 10 days, according to Judge Sheindlin's original decision. Mike Williams, the USC wide receiver, as we mentioned in the second reel, also comes back to that and it enters the draft kind of badly because he takes the money from the agent and doesn't move on. But interestingly enough, he is the only one who follows Clarett into that decision, into that category. So we have an interesting time. Clarett's a winner, the NFL's a loser, and a lot of us thought that the NFL would not allow Clarett to go to appeal because remember, the decisions of appeals courts have much broader reach than the decisions of trial courts. And if they could render Clarett's claim non-justiciable by allowing him in under a special exemption, allowing him into a supplemental draft where he could be picked, all things that would probably make him happy, but remove the specter of further litigation or a negative decision. We all expected that to happen. The NFL, on the other hand, allowed this to go to appeal. They moved it to appeal themselves, aggressively so. And most antitrust lawyers thought the NFL had no chance. The second round in the appeals court, again in front of Justice Sonia Sotomayor, now the U.S. Supreme Court, took a radically different turn. In fact, the NFL's prior argument about the non-statutory labor exemption is the thing that carries the day. Now, the non-statutory labor exemption should give you some clues as to where it exists. Well, let me tell you where you won't find it, hence the words non-statutory. You won't find it in the statutes. It's not in the legislative history, or it's not in federal compendium of law. It is a judge-made doctrine. It comes from a U.S. Supreme Court case, Jewel T. And it also comes from a second case called Pennington. Those are the two primary cases in which the Supreme Court has enunciated a doctrine, a judge-made doctrine, called the non-statutory labor exemption. It deals primarily with collective bargaining agreements where some fraud has taken place and something that should have been in and was the subject of arm's-length collective bargaining has been left out. In the Clarett case, it's not a question of fraud, it's a question of something just having been left out. Not that it wasn't things that they had fought over, but that the bylaws in the NFL, where the rule that prevented Clarett from entering the draft was contained, was never codified into the collective bargaining agreement. So hence it wasn't in the CBA. So in Clarett, you see a possible application here that Judge Sheindlin rejected because of the NFL's status as a monopoly. You see the application of this new doctrine, the non-statutory labor exemption. I like to call the non-statutory labor exemption the double secret labor exemption after Dean Wormer and the movie Animal House, where he tells the Deltas, the Animal House frat, that they're not on probation, they're on double secret probation. The other thing that I like to liken the non-statutory labor exemption to is DNA, deoxyribonucleic acid. Well, why do I like to do that? Because there are millions of strands of that in every living cell. These strands are as long as 6 feet long. There are millions of them. They're microscopic, and no one has ever seen one. Well, if it's 6 feet tall or it's 6 feet long, and there are millions of them, I would hope to have seen one. And it is interesting how this non-statutory labor exemption kind of just pops up out of nowhere and is argued by the NFL. It's worth taking a second here to at least talk about appellate process. And if I'm boring you to tears here, talking to you in front of a white screen, I kind of understand. Let me bore you a little bit more with talking about how cases go up on appeal. When you appeal a case, well, winners seldom appeal cases. Let's start with that one. Although in the new case that's coming before the U.S. Supreme Court, American Needle, the NFL at least joins in the appeal because they think they're going to have nothing to lose because they won the first 2 rounds. But generally, a winner never appeals a case. Only losers appeal, and losers usually appeal on one of two standards. They try to argue that the trial court abused its discretion or made an error of fact and law. Well, you don't get a complete retry on appeal. You usually get a very framed issue appeal unless you can show that there was some horrible mistake of fact and law that would entitle you what lawyers call de novo, or review as new, in other words. But for the most part, appeals courts are always looking for error that the trial court committed, not a whole new idea or a whole new facts. In a lot of cases, in fact almost all, except in cases of ineffectiveness of counsel, or some case where a ruling had been precluded and evidence had been precluded, in most cases you're limited to argue on appeal what you argued in the trial court. In fact, oftentimes you have to argue in the trial court to preserve that issue for appeal. You have to object, you have to make a complaint, you have to raise something to preserve that on appeal. So Clarett isn't getting a new trial on appeal, or the NFL is not getting a new trial on appeal. They're saying Judge Scheinland's decision erred in ignoring some existing fact of law. What's that existing issue? Here it's the non-statutory labor exemption issue. Judge Scheinland decided this almost exclusively on antitrust ground. NFL's a monopoly, rules arbitrary and capricious, it diminishes the marketplace, clearly it hurts Clarett, let him in, let's let him play, no reason to stop. The appeals court in this case decides this case exclusively on labor exemption grounds. And the labor exemption we're talking about here is the non-statutory labor exemption. The non-statutory labor exemption comes into play in part because the NFL Players Union agrees with the NFL that this 3-year rule is something that they don't mind, something they have fought over or would have fought over in the past, because they've certainly fought over a lot, so much so they even decertified as a union at one point and sued the NFL and Antitrust to get benefit of that in the 1990s. So they have a history of fighting over stuff and arm's-length collective bargaining. Well, clearly here they say, we don't mind this rule, we've certainly known about it, we've talked about it, just because it isn't in the collective bargaining agreement, it shouldn't be a problem. We're okay with it. In fact, we don't want Clarett in because he's going to take a job from a current union member. We have a finite number of jobs. So we're looking to protect a current union member, not Maurice Clarett's rights as a 19-year-old, 2 years out of high school to enter the NFL. In fact, we've made an agreement with the NFL on that. We kind of feel strongly about that, and we're in agreement with them. Odd position for a union to keep somebody out. Unions usually want people in, but this is pro sports, and unions are different. Unions are a symbiotic partner of management. They're not so much the opponent of management. Enough said on that one. Okay, in the second case, the court relies on a decision involving Leon Wood that the Second Circuit also previously rendered. Leon Wood was a basketball player who sued to invalidate the NBA draft, saying he'd never been a signatory to the collective bargaining agreement, he'd never been represented, and moreover the draft clearly had an anti-competitive effect. The Second Circuit in the Leon Wood case had said that the non-statutory labor exemption, because the draft was not located in the collective bargaining agreement in basketball, but had been given the full view of the players' union and full prerogative of the players' union to agree with it, they said it's okay, we're going to uphold it anyway. Even though it's not in the collective bargaining agreement, we're going to give it the benefit of the labor exemption. And that basically articulates a policy, and a very liberal policy, if you're thinking about it, a Keith Olbermann MSNBC kind of policy rather than a Fox News Bill O'Reilly kind of policy, where the courts say we're going to, rather than enforcing the antitrust law against the monopoly, we're going to give the antitrust exemption to benefit labor unions and their employers in the collective bargaining process. The non-statutory labor exemption is a very pro-labor doctrine, and we're going to give full benefit of this effect. Interesting. We see a very different case emerge. I'm going to stop this reel. We'll pick it up in the next one.